Hi, and welcome to Dollars and Making Sense, a weekly show about finance, money, and investing. I'm your host, Ray Treverson from OTG Capital. Always a pleasure. Justin Bott, the Media Information Officer from Services Australia. You may know them as Centrelink. And they also do family assistance payments and a whole range of really, really cool things. A total sideway plug for their financial information officers as well. I've been mentioning these guys with other people that I interview because, again, the cost of financial advice is becoming one of those things that a lot of people are very concerned with. And yet there's this wonderful resource. They're not financial planners, but it's a really good place to start. Just a quick shameless plug there for Services Australia, Justin.
I'm also going to throw it in and say, and there's one that works out of Brookvale on the northern beaches of Sydney. So if you want to have a chat with one, the officers at Ringa Mall, make an appointment, sit down and have a chat.
And even though this show is national, we also go, this is national, this is local on Radio Northern Beaches, but we're national through the Community Radio Network. You're normally introduced with that. That's right. We broadcast locally on Radio Northern Beaches and around Australia on the Community Radio Network. I forgot that bit in the lead in. Anyway, if you're interested, ladies and gentlemen, if you're not in the Northern Beaches or Sydney area, there are these community officers all over Australia. So look it up on the web, check them out. They're nice, friendly people there to help. And so, look, today, I guess it's one of those things that when we're talking about estate planning, a lot of people don't worry about it too much because they don't really think about it because they're going to die or it's an imminent thing or they've just watched somebody in their close family. But this is something we should be thinking about quite a lot and settling down into a process. Isn't that right, Justin?
Absolutely. This is the conversation that is appropriate. And again, it's a practice, but not preach thing, or don't practice what I preach. If the moment you've turned 18 years of age, if you've got an asset, then you need to think about estate planning because it's just the nature of the world that not everybody goes through life and lives the full gambit that they could, and things happen. And it might not be that you pass away sooner than you might have otherwise hoped, but you're not in a position to make decisions any longer and you need somebody else to help do those sorts of things for you. And that can happen at any age and any stage. So, most young people think that they are super people, that they will live forever and they'll never be unwell.
Bulletproof.
It's not the actual case. And so having the proper documents in place is just it's a gift for everybody else because everybody around you's life is going to be so much easier if you have these documents in place, instead of having to go through the process of getting the authorities they need to get to make the decisions that need to be made. So what we're going to be talking about in these particular documents, again, any stage, any age, is the sort of thing people should be looking at.
Okay. So in that case, what's the first one that they should be thinking about?
First one, the big one, is the will. So the document that you then set out your wishes about what happens when you pass away. So we're looking at who do you want to look after your estate, which is known as your executor, how you want your assets to be shared, who's going to be looking after your young children, whether you want to support charities. And that might not be something that you think about, but if you don't have a will and it becomes, which we're going to talk about, becomes intestate, the government's not thinking of charities when they're thinking about how they're going to distribute the money on your behalf. So if you are passionate about particular charities, then you need to have a will to be able to make that distribution to them because otherwise it's not going to happen. And also issues about what you might want to do with your funeral. So if you don't have a valid will, you are what's known as intestate, meaning you haven't told anybody what you've done and somebody's going to have to make the decisions about how your assets are going to be distributed. So there's going to be an appointed trustee or executor. And depending on the state that you live in, they've got different names: public trustee, trustee and guardian. But there will be a government-appointed agent who will be making the decisions on your behalf. Now, that doesn't mean, as a lot of people think, that the money goes to the government. Just because the government has appointed an agent to make your decisions, that agent then has to work under the government structure of where your money is going to be distributed. And if you are the nuclear family with mum, dad, and a couple of kids, that's easy. There's nothing complicated. It's very firm. They know exactly who the money should be going to, and they will pay that out for you. And as long as you didn't ruin anything else, then that's going to be fine. But there are so many families nowadays that are not a nuclear family. They've got children from previous relationships, and step kids and previous wives and original children from previous partners. And how that money is going to be distributed is not going to properly reflect what your wishes may well be. Now, I mean, the government will do the best it can, but realistically, it's going to be a point where they just can't do that. So in order to make sure that that doesn't happen, and in order to make sure that the money goes to the people that you want it to go to, you need to have a will that sets all of that out. It needs to be a proper, legally binding will that meets the requirements. And that means the terminology is correct. You know, we watch a lot of American TV where they've got videos about how to do wills, or they've written it on the back of a napkin. None of that's going to work in Australia. That's not how our system works. You need to be going through a properly worded will using the right terminology, properly making sure your assets are accurately and equitably distributed. Otherwise, the will may be determined to be invalid, and therefore you're back to the situation of being intestate, and then you're back to the situation of the government determining who's going to be getting the money. So having a properly worded will is an essential.
I guess one of the other factors that I know, I was in the armed forces when I was 18 years old, and wills were one of those interesting things that we had to fill out in case we were deployed. Now, the other factor, and this also, it's a bit of a furphy, but organ transplant desires are usually put on driver's licenses, and yet they still get challenged. And how do I know this? A very dear friend of ours through my daughter's school on the northern suburbs, she's a transplant nurse. And even when people tick the box and say, yes, I want to donate my organs, they still end up having a bun fight because if family all of a sudden step in, it muddies the waters. Putting that in a will as well and communicating that well before the day they die sometimes is useful. And I've had some really good estate lawyers on the show where they talk about, you know, the place to start is a piece of paper and a pen is a great way to start drafting a will. And even for an 18 to, let's say, 30-year-old, because a lot of people aren't getting married before they're 30 these days. So think about when they're single, they will still have assets, they will still have wants, desires. I mean, gosh, my daughter gives to so many different charities. And if she leaves that in her will, I think it's just a mark of respect that says, you know, what are your desires if you're no longer around? And so, Justin, is there, and again, I'm not looking for a cheap or easy way, is there a useful way? So if we go to Money Smart, are there some resources there that people can look at, or at Services Australia, if they need to do this without engaging what in many people's minds might be expensive lawyers in this space?
Certainly not through Services Australia. This is not something that we actually are involved with. Money Smart will have information about the need for having these, but they won't, from memory, they don't have the documents there. There's a lot of community groups that will have free will services or free will kits that you can go online. So like St. Vincent Paul, Salvation Army, those sorts of issues, they will have free ones through them.
Yeah. They normally have a little clause in there that includes them, and I'm a little bit dubious about that. I was going to mention the various state law societies as well will have template type of documentation as well.
Yeah, it's so, and there's things like, as in trustee and guardian, where you're not paying for the will creation, but then you've got to pay for the estate planning, the estate management side of the story as well, or of course your legal professionals. It's the same sort of issue that you might have with any other sort of investment, though. The more complex your structure, the more likely you're probably going to need a professional to help you. If you've got concerns about control of the money once you passed away, you may have family members that are entitled to the money, but you know that they're not in a position to be able to manage that money properly, then you're looking at testamentary trusts where you've got somebody else who's going to be managing the money for them. Then you're going to be needing legal professionals to be able to set these structures in place. So if it's a very simple situation, again, that whole nuclear family, which doesn't require a lot of work, then yeah, that's not going to really need a complicated will to make that happen. If I've got a more complicated structure, I've got a more complicated business structure, or a complicated investment structure, or a complicated family situation, then it may well be that I'm going to have to pay to get a properly worded will to protect everybody in the way that I want to have everybody protected. So horses for
Yeah,
courses from that perspective too.
yeah, I might air an element of caution. There are many agencies out there that will offer free wills, but you pay for it. And you've mentioned already, Justin, that you may get the will for free, but then the trustee services that are the sting in the tail. And I've read some horror stories about that, where, yeah, the will was free, but man, they were paying through the nose for the services after. And because they'd signed those rights away in that will, unwittingly and unknowingly, they're sort of caught. Look, we're just about half time. You're here on Dollars and Making Sense, a weekly show about finance, money and investing. I'm here with Justin Bott from Services Australia. We're going to take a short break and be back in just a moment. Hi, and thank you for listening to Dollars and Making Sense, a weekly radio program about finance, money and investing on Radio Northern Beaches and nationally on the Community Radio Network around Australia. The views, comments and opinions aired during our program should not be construed or viewed as financial advice. Any commentary is general advice only and does not take into account your objectives, financial situation or needs. You should consider whether the advice is suitable for you and your personal circumstances. If in doubt, you should contact an authorised licensed financial planner. We welcome questions and feedback, and you can get in touch with us via our blog, social media channels or email. Please search for Dollars and Making Sense in your favourite podcast platform or check out our blog at otgcapital.com.au/blog. Hi, and welcome back to Dollars and Making Sense, a weekly show about finance, money and investing. I'm your host, Ray Treverson, and at the microphone this week, we have Justin Bott, Media Information Officer from Services Australia. We are talking documentation for people that die. Now, before we went to the break, we were talking about the last will and testament and how important that baseline document is. But given the fact that we are living much longer lives than we have, say, 50 or even 100 years ago, the place where the next document has in our society is taking on far more importance than it ever has. Justin, what is that document?
So this is for people that haven't died, and this is called the power of attorney. So power of attorney is a document where you're authorizing another person or persons or organization to make decisions on your behalf when you're not in a circumstance where you're able to do that.
Right.
Now, we have something called a general power of attorney. And again, be wary because they get a little bit of different names in different states or territories. So it's always good to check out your own state and territory website to check what the proper titles for these things are. But generally speaking, a general power of attorney is something that actually goes for a limited period of time. And you are certainly mentally capable during the period of the power of attorney. So a classic example would be that I'm traveling overseas for 6 months, and in that period of time, a significant, I have to sell an investment property or other significant business has to happen while I'm traveling. It is too hard for me to communicate from England to Australia at that time of night. So I give general power of attorney for that 6-month window for somebody to do the business while I'm away. At the end of the 6-month window, the general power of attorney ends and that person's power is gone. The other one, which is the one you're not talking about mostly, and the one people think about, is called an enduring power of attorney.
EPOA,
that one,
yep.
That's the one that takes over when I am no longer able to make decisions. And that will go basically until I'm either proven to be in a situation where I can make decisions again, or realistically until I pass away. So this is the, I might be dealing with dementia, facing, I might be even physically, it's just too hard for me to physically get everywhere I need to go. And so I authorize somebody else to do that.
I guess the backdrop here, ladies and gentlemen, Justin, is that we're talking about now that if the statistics are real, and I'm sure they are, 1 in 3 will get Alzheimer's or some form of degenerative memory loss. My own mum had it for the last 3 years of her life. It's pretty awful to have to live through. My sister took the brunt of the caring, but having the EPOA in place well beforehand saved a lot of hassle. And again, I'm curious then from a Services Australia perspective, how does the EPOA play out in your daily operations, in your interactions with the public that you serve?
Yeah. Now, so a couple of points, and you made a really, really good one there. This document has to be made when you don't need it. Everything we're about to
So
be
you're not
talking about,
doolally. You're not doolally yet.
yeah, you've got to be able to understand what you're getting yourself into and what you're giving this person the authority to do. And if you can't be proven to do that, then you can't make a power of attorney or anything else that we're talking about. From a Services Australia's perspective, we absolutely will work with powers of attorney. So either you as the customer or the powers of attorney can bring the document in. There may be multiple people. We can register the powers of attorney, and we will give them the authority to act on your behalf as set out in your power of attorney document. So they're not all universally, they could do everything. And so whatever restrictions you may put in that power of attorney document, we will incorporate in the business that we do. In saying that, we work better with our own internal system where we set up a nominee arrangement where we authorize a person to do transactions and things on your behalf.
Right.
It works better with our internal systems, as in we can mail things out to people more effectively. You're able to do things online more effectively as a nominee than you could be able to do as a power of attorney. But in saying that, you're only allowed to have one nominee, but you can have multiple powers of attorney. So if you've got a power of attorney structure that allows for, we've got 3 kids and you want them all to be powers of attorney, that's all fine of the power of attorney document. That is not going to work with our nominee. We will only have one person that we give that power to. So it may be that a nominee arrangement just doesn't suit what it is that you've got in place.
Yeah.
But either way, we can work with powers of attorney, we can work with nominees, we can work with both of them, whichever way you decide to go.
So I'm curious then, the focus of the power of attorney is to make decisions about financials and property, but there's a lot more decisions that are involved here. What are some of the other considerations that we're thinking about?
Yeah, so we've talked about what power of attorney, as you said, is finance and property. That's what they're there for. But there's much more to life than powers of attorney. So you need your number 2 in your trifecta of documents when you're looking at estate planning, if we're not counting the will. Will is a separate one to these. Right. It's called an enduring guardianship or a power of attorney over health, but this thing's known as an enduring guardianship. So an enduring guardianship is where same sort of concept, but now you're authorizing a third party to be able to make decisions for the other sorts of decisions that you make in life. So it's not about the money and the finance, it's about personal decisions. Where am I going to be living? What sort of medical treatment do I want to have? How do I want to enjoy the last few years in life? And I need to have an enduring guardian to be able to be the person that makes those sorts of decisions. So how am I going to enjoy the money that I might have, rather than just how do I invest it or what do I do with it? So like the power of attorney, this document has to be created at a time when you're understanding the authority that you're giving the guardian, and it stays in place as long as you're not in a position to be able to change it. So if you're not capable to make the decisions for yourself, enduring guardian will stay in play. Either you become capable in the future or you pass away and the enduring guardian goes all the way through until your death.
Wow. Okay, so these enduring guardianship, is this something that they then you would download this document? I must admit I've heard about the EPOA quite a lot in the will, and they tend to be the 2 major ones. But the guardianship I always thought was hand in hand with the EPOA. This sounds like it's quite a separate arrangement then. Is that right?
Realistically, you would be, hopefully any solicitor would help you set them both up at the same time.
Okay.
Now, it's important to say that you can have the same person as your power of attorney, the same person as your guardian. There's nothing to stop you from doing that. Right. There's advantages of that. There's also advantages of having them as 2 separate people, depending on your circumstances. But it's really important to say that a power of attorney and your guardian need to be able to work together. And aged care is a great example to explain that. So if I've been assessed as requiring aged care, then my power of attorney will help work out, do I have to sell my home to be able to make that happen? What sort of fees am I going to be paying? How do I invest the money after I paid the fees? So the sort of lump sums and how am I going to fund that? The guardian is then going to decide why this aged care facility is better than that aged care facility, why I want the room on the 2nd floor with a view, what sort of medical services might I want, do I want to have wine with my dinner? They're all the decisions that the guardian's making, but the power of attorney is not, because it's got nothing to do with money or finances. Now, obviously, the power of attorney, so the guardian's going to be making decisions that's going to add to the fees potentially, so they need the power of attorney to work with them to accept that that's going to be the case. the power of attorney wants to make decisions based on money. Well, this is the cheaper one, but the guardian's saying, yeah, but it's horrid. We want that one. So they've got to be able to work together and communicate together to be able to make the decisions. Now, again, obviously, if they are the one person, then that's all going to be taken care of in the one role. If they are two separate people, then they need to be able to talk to each other, need to be able to make decisions. They need to be able to make big decisions and important decisions. So you've got to, obviously then understand who you're giving these powers to, because you're not doing them any favors. This is a really important thought. Often people treat power of attorney as I'm blessing you with the right to be my power of attorney. How honored you should be that I'm giving you that much trust. The reality is I'm asking you to manage my life on top of your own. I'm not doing you any favors by making that. I'm making your life harder. So there's got to be somebody who can manage that and do that. So if it's somebody that's also managing kids and all sorts of other things going on, do they have the capacity to be your power of attorney at the same time, your guardian at the same time?
I've got to tell you, Justin, of everything we've talked about so far in the program, that is the jewel. What you've just said, that is the jewel in the crown, because it's that element of, appointing the EPOA, but also, for example, the executor of a will. And I've seen that gone awry, because you've just highlighted, I think, what most people totally ignore. And I saw it happen where the executor and ended up being the person that needed to do all the heavy lifting after somebody had passed away, was a full-time mum, with kids and a busy job and a whole bunch of other stuff going on in her life. And then the expectation of lumping all of that as well on this poor person's shoulders was really quite something. And I've watched it from afar, scratching my head going, I don't know if that was necessarily a good decision. And ladies and gentlemen, if you can go back and listen to that last couple of minutes again, Justin, they are incredibly wise words of wisdom, because it's anything but a blessing. It's something that, my wife and I are in our 60s now. We've got to actually sit down and do this stuff, because we haven't touched our wills since before our kids were born. So that's a long time ago. And we've got to sit down and do it just as a matter of principle, because it's out of date. And if we were to die intestate right now, it would just cause a lot of admin hassles that we're pretty comfortable. The process is straightforward, but we give that gift of untangling the mess, I think, because that, together with and again, ladies and gentlemen, this Justin may not, on this part, but superannuation is different to this as well, because binding notifications on super have nothing to do with your will and testament. Okay, so don't lump the two together. They've both got to be done, and they're totally separate items. So I think, Justin, wow, there's some really good stuff here. Again, where's a good place to start resources-wise when people need to start researching? Where's a good place to go?
The power of the internet. I actually, again, Money Smart's got information to give you the history of the basics of what the role is. But if you want to be able to find, what wording do I need to be using and all those sort of things, then it's back down the legal channels. The other one that you just mentioned very quickly, you said super. The other big one that's often not in the will is the family home. If the family home is owned jointly, not owned by tenants in common, but joint tenants, family home automatically goes to the other owner, therefore is not part of your will. And if you write it in your will out of ignorance, you've actually gifted an asset you can't give, and your will has become invalid, and then you're back to intestate. So these are the sorts of little fine-tuning problems that can happen if you don't do enough research to work out what you're going through. The last document we need to very quickly talk about is called an advanced care directive. An advanced care directive is where you are actually setting out your medical requirements. This is what I want to happen should I ever get into a situation where I'm medically affected and I'm not able to look after myself. Basically, we're talking about end-of-life sorts of decisions.
So this is do not resuscitate type stuff as well?
That sort of stuff. So like the other documents, the advanced care directive needs another person to be the one that's making the decisions on that. Now, this person is potentially going to be the one that has to say, mum or dad want to pass away, we'll let mum and dad pass away. This is not an easy job.
That's
So
not easy at
again,
all.
you've got to think really hard about who the people are that you want to be doing this. Not only do they have to be responsible, know what you want, which you're setting out in your advanced care directive, know your wishes, know the sort of lifestyle you want to live, be able to make really tough decisions at a really tough time when nobody else wants to make decisions. But, and I know this is ridiculously practical, they have to be easily contactable. It's the same with all of them. You need to be able to speak to these people. You need to be able to get to them over the phone. So, same sort of issue that if they're so busy with the rest of their lives that you just can't speak to them, then, or their job is so busy they're not available between the hours of 8 a.m. and 6 p.m., then maybe this isn't the right person for you.
Yeah.
So you got to think about those practical issues as well. So advanced care directive is the last one in the list of the 3 that you really need to have. Will, then power of attorney, enduring guardian, advanced care directive.
Fabulous. We're out of time. Justin, what a fabulous education piece we've done today. Ladies and gentlemen, I hope you appreciate some of the absolute pearls of wisdom that Justin's been able to give us from Services Australia. Until next time, Justin, thanks for being on the show.
Thank you so much for having me. It's always a pleasure.
Cheers.